And welcome back. For our second big story this morning, we turn to one of Nigeria's hottest industrial flashpoints. The shutdown suspended but not fully resolved between PENGASSAN and the Dangote Refinery. Over the past week, the union rocked the energy sector. It ordered a cut in crude and gas supply to the Africa-scale refinery, threatened nationwide disruption, and demanded the reinstatement of over 800 sacked workers, all in defense of union rights. A federal government brokered meeting produced a communique, and the union announced a suspension of the strike, but it explicitly warned that any breach would trigger a resumption with no further notice.
So yet tension remains. And PENGASSAN says it never signed any agreement and notes gray areas in the deal. Meanwhile, stakeholders, critics as well as legal voices are calling for clarity, lest this may be merely a truce before a bigger explosion. And so to help us navigate the legal, labor, and industrial dimensions of this development, we have with us, joining us virtually, Ireoluwa Oguntuase. He's a distinguished labor lawyer, and he joins us live virtually. Good morning and welcome, Ireoluwa. It's good to have you join us this morning.
Good morning.
Yes, good morning. Good morning. I hope you guys are doing very wonderful in the studio.
Yes, we are. Since I refused to join us in the studio, we're doing well. I mean, first of all, happy Independence Day, by the way. Belated Independence Day, 65 years. 65 years into our independence, we are still at this crossroads when it comes to unionism and, rights of workers, private sector, public sector, which should be oil sector in limbo. So in your legal assessment, was PENGASSAN within its right to order a halt? I think that's the biggest conversation here, biggest bone of contention throughout the entire week when this started, whether PENGASSAN was within its right to halt a gas and crude supply to Dangote pending adjudication. How does that square with labor law or industrial relations precedents?
Okay, so we need to identify something, the implication of what PENGASSAN did. The implication of what they did can actually lead to an act of economic sabotage. And when we have a sector as sensitive as the oil and gas sector, we need to be very careful on how we navigate issues in that particular sector. Now, we're all in this country, and we witnessed fuel shortages. We witnessed how we struggle for fuel. We witnessed how our resources, were squandered on this seeming repair of the refinery, that never came to pass. And still, on this basis, we still witness a situation whereby someone had said, okay, I can do this, I can manage this. We all thought it was a joke because of, the seeming murky waters. We thought nobody could navigate through it. But here we are now. And so how do we now see this? For someone to now say that, okay, what this person is entitled to for the purpose of ensuring that Nigerians actually enjoy a seamless distribution, a seamless flow of oil and gas, is not going to get it because of the interest of 800 workers. I don't think that is appropriate. I think there are more creative ways to navigate issues of sabotage. We need to first identify the PENGASSAN and Dangote. Is a trade dispute. And PENGASSAN are acting on behalf of the employees of Dangote who they claim they are their members. Please, let me quickly say that I'm totally in support of an employee joining a trade union. And not that I'm just in support of it, I'm in support because the law
seems to be having.
Ireoluwa, if you can help us turn off your video, I think that would sort of help with the audio for now. If there's a chance, you can help us turn off your video so that I think that the video is lagging, it's making the audio lag because we're having difficulties hearing you.
And collective right to organize, about right to organize and now.
Yeah, so
can you hear me now?
Yes, I can. Yes, I can. I can hear you loud and clear.
Oh, okay. So what I was trying to say is that it is the right of the employees to join a trade union. Now, and I've cited sections of the law. I cited section 40 of the 1999 Constitution. I cited section 9, subsection 6 of the Labour Act. I cited ILO Convention 87 that talks about freedom of association and collective freedom of association and protection of collective interest. Now, I also cited Convention 98 that talks about right is right cumulatively. If we read them individually and collectively, communitively, they all tilted to the fact that employees can join trade union. Now, trade union is now acting in the interest of these employees, and in the process of so acting, there has been a trade dispute between the trade union representing the interest of the employees and the employer. There are creative ways to solve it, and I dare say, when I say creative way to solve it, I don't mean involving in an act that can lead to economic sabotage. That is very dangerous. It's very dangerous, I dare say. And why do I say it's very dangerous? Even if I really need to commend the federal government for being matured about the way they settle the disputes. Because if the federal government had looked at the Trade Dispute Prohibition Act, the Trade Dispute Prohibition Act that allows the federal government to actually prescribe the trade union, then we may not be talking about it, because it would have been, a snowball between the federal government and PENGASSAN. Because what PENGASSAN has done to a very great extent is capable of shutting down the economy. So I think that going forward, I think parties should have learned their lessons from this, especially PENGASSAN. And I think that going forward, when issues like this happen, I think PENGASSAN should find a more creative way. What of negotiation? Now, I believe that PENGASSAN should have, in the first instance, commence negotiation immediately with Dangote. If negotiation fails, then they can as well report the issue to the federal government so that they can apprehend the dispute and they can come in. Right. Now, we are witness to the fact that eventually it was federal government that resolved this dispute, but that could have been done without PENGASSAN doing what they did. I don't subscribe to that. Now, federal government, and I wish that in subsequent times they can change their procedure or strategy.
Ireoluwa, but it seems that we have a problem down the road. Whether or not, for federal government to have stepped in, there seems to be a problem down the road with PENGASSAN now saying that it did not sign any formal agreement with Dangote. But we're going to get into that. We want to fix your connectivity. We seem to be having issues with your network. Let's go on short break. You're watching Breakfast Extra here on News Central. Our guest today is Ireoluwa Oguntuase. He's a labor lawyer, and we're just discussing the PENGASSAN and Dangote dispute that happened over the week with the reconciliation that federal government did have to step in. Let's go to short break. When we come back, we'll continue the discussion. Stay with us. So earlier, before we went on that break due to network connectivity, you were talking about, how PENGASSAN, you stand for the rights of workers, but there was so much when it comes to them, meddling with Dangote and what it meant for our crude oil refineries, and just pretty much shutting down the economy and the nation due to this action by PENGASSAN. But you also preempted a problem that would be on the way, that's going to be we're kicking the can down the road. And let's preempt that, because PENGASSAN has said that they did not sign any formal agreement with Dangote and described the outcome as, a lack for a better word, just a pause for now. If a formal agreement isn't signed with Dangote, what do you preempt will happen in the future?
Okay, so when we talk of the issue of whether they sign agreement with Dangote or not, I think we need to move beyond that, and we need to move to finally resolving the issue. Now, for now, the issue has been, at least on the face of it, resolved by saying that the workers that are involved will be reabsorbed into other subsidiaries. Now, if that is done, I think that should end it, because we also should not forget the fact that there was a trade dispute between Dangote and PENGASSAN. And this trade dispute was apprehended by the federal government. And in the apprehension of the trade dispute and the resolution, at least on the face of it, there is this resolution on the part of both parties that the employees that are being involved in this will be reabsorbed. So without prejudice to whether a collective agreement is signed or not on how they are going to resolve it, everybody is aware of what parties, agreed on. In fact, I'm also aware that PENGASSAN even came out to admit it, that this is what parties have agreed on, on the face of it. And in fact, admitted, need no further proof. That's the position of the law. So to that extent, I would think that if Dangote can go ahead and implement what has been agreed on by reabsorbing the workers that are involved into others Dangote subsidiary, in consonance with what parties, discussed. I think that should reasonably solve the issue and parties can move on peacefully.
Right. So if for instance, if the conflict continues, what legal principle or precedent would govern whether PENGASSAN can legally resume similar actions?
Okay, so when you say I think if I understand you, you're trying to say that if the dispute continues, and that's why I said the other time. Now, can that dispute continue if Dangote reabsorb the 800 workers into the subsidiaries? I don't think so, because that was what was agreed on between the parties, whether they sign an agreement to that or not. PENGASSAN came out to also admit that this is what they agreed on. And I think I also watched, the meeting on the TV where they said that what they will just be doing is for them to wait and see whether these workers are reabsorbed back. And that's the basis upon which they suspend the strike. So for the issue to recommence, for the dispute to commence again, is going to be if Dangote fails to reabsorb into the other subsidiary, and I don't think Dangote should fail to do that. In fact, from what I heard that the position that was finally adopted was even a position that during negotiation between Dangote and PENGASSAN, it was a position that Dangote has already broached to them that can we have this? Can you guys have this for us to resolve this? And unfortunately, they said no. They maintain that they must be reabsorbed back into Dangote Refinery until the federal government came in. So I will assume that there will not be any dispute again. But assuming without conceding, assuming there is now a dispute. Now, for PENGASSAN to decide, before they can decide to now take the action that they took, I think, there are specified procedure under the law, the Trade Dispute Act, that states that when there is a dispute, this is how it should be resolved. Section 4 of the Trade Dispute Act is very clear. Mediation. Section 6, conciliation by the federal government. And even if we now look at that provision of the law till Section 18, it prohibits PENGASSAN from doing anything until they've exhausted the procedure for resolution of dispute, both internal dispute settlement machinery and external, which is mediation, conciliation, industrial arbitration panel, before they can even proceed to do anything. And if we also look at the Trade Dispute, the Trade Union Amendment Act, 2005, particularly Section 31, subsection 6, it also lists procedures that trade union must pass through before they can decide to go on strike or do any form of industrial action or something relating to that. So I would believe that these are the things that PENGASSAN should be looking forward to exhausting before taking an action. But I would also tell you, unfortunately so, that we've witnessed a situation whereby procedures are practiced in abeyance of the law. Procedures are done, or things are done, actions are taken, conduct are performed without not considering the law. I want to believe, and of course, expectedly, rightly so, that PENGASSAN is a product or conception of the Trade Union Act. They are registered under the Trade Union Act. So this being so, they are also bound to follow the law as contained in the Trade Union Act and the Trade Dispute Act and other enabling law. So in as much as they have the right, I wouldn't say that they don't have the right to strike. Please, I will not say that, because there is a procedure, but there's a procedure for them that if they want to embark on strike or if they want to pick it or do something, these are the things that they need to do in the Trade Dispute Act and also in the Trade Union Amendment Act. And those are the things that they must do. It is not a discretion on them. The law doesn't place it as a discretion. The law places it as a mandatory obligation on them. But we've witnessed a situation whereby several strikes has happened and several trade unions have gone ahead to get themselves involved in industrial dispute without not following the strict procedures. So I would think that it's high time we start following the law to the latter, because there is even a punitive provision in the Trade Union Amendment Act of 10,000 for trade union that failed to follow that procedure before going on strike, and even imprisonment for 6 months or more. So these are things I believe that they should start doing, else we should start enforcing the law. Because I wouldn't want a situation whereby Nigerians will suffer for the action of a few, for the failure of someone not to strictly follow the law. So I think that parties at this juncture should be aware of the enabling legislation and follow it to the latter. That would be in the event that Dangote fails to implement what parties have agreed on.
Right.
There's a twofold question that I have for you. I think the first was, prior to this suspension, the National Industrial Court had issued an interim order restraining PENGASSAN from cutting gas and crude to Dangote, citing risk of irreparable damage to the economy. And we saw that with 60% decline when it comes to oil barrel productions or crude oil production in our economy. So how do such interim, rulings interact with constitutional labor rights? I want us to discuss on that. And as we're talking about that, what precedents is this action from the union set? Possible, precedents is set, for just future reference?
Is a precedent of impunity. Let me start from there. Is a precedent of impunity. The law is very clear. The court has the right to adjudicate between parties. Section 6 of the 1999 Constitution is very clear. Now, Section 287 of the 1999 Constitution as amended is also very clear to the fact that when a court makes an order, parties are bound to abide by that order of the court. That's why the court is created. That's why we are not in a banana republic. So the court has given an interim order. As much as the order is interim, the court can also renew it subject to some facts and circumstances. But to the extent in which the order has lasted, parties are bound to follow strictly the order, to comply themselves stricto sensu with the order. So if as at the time the court gave the order, if after this time PENGASSAN went ahead to now do what they've done, I think that is extremely contemptuous. And I think that when we have things like this, at least on the face of it, so that citizens will not feel that the court just merely they are built or they exist in abeyance, that they are toothless bulldog. There are also ways or procedures when someone fails to follow the order of the court. There are ways in which that person can also be punished. That person can be brought to court to come and tell the court, to come and show cause why that order is not being fulfilled. But in the name of we are trying to settle a dispute, and we also don't want to conflagrate, the situation. We don't want to eat up the situation. We have a situation whereby all these things are pushed to the minimum. But again, I don't think that is fair, because they would also do it again. And that's why I said it's a precedent of impunity. If a court has given an order, a court of competent jurisdiction, National Industrial Court, pursuant to Section 254 of the Third Alteration Act, 2010, they gave an order, and a party against whom the order is given, now fails to, except they say that they are not served with the order or they are not aware. But if they can show, or it can be shown that they are aware of that order, but they flagrantly refuse not to follow it, I think that's extremely contemptuous, without prejudice to any law that we have. Because even if we look at Section 40 of the 1999 Constitution that regulate freedom of association, and by extension says that, trade union can go on strike or get themselves involved in industrial dispute. We should also note that there is also Section 45 that now says that, nothing in Section 37, 38, 39, 40, and 41 of the Constitution shall invalidate any law that is reasonably justifiable in a society, in the interest of peace, in the interest of national security, in the interest of public safety, and even in the interest of also protecting the right of others. So people should not look at Section 40 in abeyance. They should also read it cumulatively with Section 45. So that would mean that where another person's right stops is where another person's right begins.
Okay, so you had mentioned that, we've talked about the sacked workers being redeployed to subsidiaries of Dangote. But the union also admitted that, there were gray areas in the current deal, like undefined timelines and, ambiguity around job placement or guarantees of, roles. People are concerned as to would they get their same roles. From your own perspective, how dangerous are these gaps? What should have been included to make that, to make this safer, to avoid, another strike?
That's a very good question. Now, when talking about gaps, and that's why in fact, assuming a court gives an order and there are gaps. I'm talking about courts now. I'm not even talking about the government. There are opportunities for you. There are windows for you to go back to that court and say, my lords or my lord, please, we seek interpretation for this order so that we can get proper clarification, let alone on the platform of conciliation. Now, what conciliation is saying, or what mediation is saying, which the federal government have done in this case, is that there will be two parties on the other side. The federal government will be sitting on the conciliatory table or mediation table, trying to make parties together. So I don't think it is reasonable for them now to be complaining about gaps. Why can't they resolve the gap as at the time these things were being discussed? These are not things that are esoteric. These are things that a reasonable person could think of. So if the proposal is that we're going to reabsorb the 800 workers into other subsidiaries, then I think the things that should have been fine-tuned there and then is the time, is which subsidiary, the names of the people that will be reabsorbed, so that everything can be very clear.
Right.
But I think for a party to now be coming and say that we have gaps, when the gap should have been resolved there and then, this is not an order of court. It is just a proposal that parties in the interest of peace and safety and in the interest of national security, in the interest of all Nigerians, they need to come together and agree on. So I think at this juncture, in fact, they can still go back. Even they can still go back to the federal government. Federal government can still call a meeting to resolve all these things. It is not late. It is not late. So I don't think that's an excuse.
So at the end of the day, there's, like you said, there's set precedents. There are still gray areas with this communique or this agreement in terms of reabsorbing the 800 plus staff into other subsidiaries of Dangote. There's also a lot of, impunity. You've said it all. And so what then happens in terms of our future when it comes to picketing, labor laws, rights, just moving forward as we sort of chart the course when it comes to industrialization, especially at the oil and gas sector, because it's still growing, and, as more private players begin to come in, how can we fine tune it, so that what has happened should not happen again?
Now, we need to consider something. Hitherto, it has always been federal government being the main player in the oil and gas sector and also managing disputed relationship between PENGASSAN and other sectoral trade unions playing in the oil and gas sector. But new thing has happened now in the sense that we now have a private employer. I've always noticed, and it's my personal opinion, please, I've always noticed that whenever there is a dispute between a trade union and a private employer, it's quite different from where there is a dispute between the trade union and the government. The government is the largest employer of labor. The government sometimes, in the interest of public safety, may even jettison sometimes making profits. But again, this may not be so in the case of a private employer, because I believe that the management of Dangote, before the refinery was constructed or established, there are a lot of monies invested into it. There are a lot of loans that invested into it. And there is no private individual that established, something as big or gigantic as a refinery that wouldn't want to make his profit within the shortest possible time, or that wouldn't want to repay the loan within the shortest possible time. So to that extent, there is likely to be tension, especially because what to be germinating in the mind of a private employer is that, well, if I allow these people, I'm saying, please, I'm not relating it to the management of Dangote. It is my opinion. Okay. If we allow these people, they may come and disrupt our operation. And we can't afford that to be done because we need to make profit. Every second counts, every minute counts. On this basis, there will be agitation, there will be apprehension, there will be preemption. And when we have all these things, it will really impact on the relationship or on the basis of the industrial peace and harmony that should naturally exist between trade union and private employers. Now, that would mean that the private employers would also want to be extremely creative, and that's why we're seeing all these things. So what I would suggest is that going forward, PENGASSAN should realize as a trade union that everything is not about strike. They need to be more creative beyond strike. Now, they need to be creative and go in depth as to also look at the principle of industrial peace and harmony and how that can be more enforced. Look at the principle of industrial peace and harmony and how that can be more enforced. So when we talk about industrial peace and harmony, look at how they can have a smooth relationship between the employers, private employers that are within the oil and gas sector, such that even when they are making their demands, they would also be making their demands, putting into consideration the interest of the private employer in the oil and gas sector that want to make profit. I think the issue that we're having here is an issue of dispute of interest. One person is saying that in making your proposal, you are not including me, in the scheme of things. And don't let us forget that the law that regulates private employer is quite different from the law that regulates government employees. The law always remains that a private employer can hire and fire without a reason. So those are the things that would also be coming into the head of a private employer. So what I would suggest is that in trying to meet with them, in trying to sit at the bargaining table with them and draw out a collective agreement, they should do it in such a way that would engender industrial peace and harmony, and not one that would also exacerbate the dispute of interest that will naturally happen between the trade union and the private employer.
All right. Ireoluwa, I must say thank you for just taking out the time to join us, in spite of how the connectivity was bad, but you still did your best to rejoin us again. Thank you so much for your commitment as well. And always insightful every time you come on. Ireoluwa Oguntuase, he's a seasoned labor lawyer, giving us a bit of insight following the dispute that happened earlier this week between PENGASSAN and Dangote Refineries.